Good evening, ladies and gentlemen. How are you keeping this lovely, lovely, lovely evening of October the 25th? It's an amazing month. It was my birthday last week, by the way. Thank you for those of you who wished me a happy birthday. And for those of you who are joining us today for the first time, welcome to Get It Right with Atara Solutions. Get It Right with Atara Solutions is a webinar that takes place every Tuesday from 8 p.m. to 9 p.m. here on Zoom, and we are also live on Facebook. We have been doing this since since 2020 of a COVID period. We are in season 3 and we are coming to the end of season 3 this November. Oh my God, it's been an awesome year. We started season 3 on the 18th of January and we are still on it until now. And we are hoping to take a break sometime in November. We have our meet and greet in November on when? On 18th of November. And we are hoping to see all of you there, even those who are saying to Peleke Ingina Mombasa. I hope you can come for the Nairobi one before we bring Mombasa, eh? Hey, because I mean, this is Get It Right. And for our partners, you can make it to Nairobi. So we're very excited to have you and we're very excited to see you this evening. My name is Grace Nzula. I am the lead consultant at Atara Solutions. I am otherwise known as moderator of choice, and I have a team here. So Kevin, you can introduce yourself, and then Catherine before we go on and introduce our partners.
I am Kevin Adipo, HR Associate at Atara Solutions, and as you can see, we are ready, and I believe you are ready as well for the end year that is with Get It Right with Atara Solutions. So I'm really hoping to see all of us in the upcoming, that is on 18th, so that we can all dance, make merry, associate together, and again, get to nurture ourselves with the knowledge that all of us have. Back to you, Grace. As we are waiting for Grace, Kathleen Sidandi, would kindly allow us to hear your voice today.
Okay, I'm Kathleen Sidandi, and I'm your sign language interpreter. Thank you.
Thank you so much, Kathleen Sidandi, for that intro. Back to you, Grace.
Okay, I think our speaker, please, our speaker, you may need to use the login on your chat, on your Facebook, I mean, on your WhatsApp. This one, the one that I have, like, this one is, yeah, the one I have highlighted for you, kindly. All right, sorry, I'm using my phone to tether because I am at the HRM that 26th annual HRM conference. So anyone on this call who is in Naivasha, please say hello to me. And I know we are trying to be here and just see how to manage some of these things. Anyway, all right, so Get It Right with Atara Solutions, like I said, is a webinar series that seeks to demystify issues in employment and entrepreneurship. We do this in partnership with a number of organizations. We have Balcon Housing. Balcon Housing is a real estate and property management company. They are located in Nairobi, but they sell land all over the country. If you're looking for a piece of land, or you have a piece of land and you wish to sell, then Balcon Housing will be able to sort you out on that. And then we have Stallion Construction Company. Stallion Construction, like the name spells it, is a construction company that is in the business of construction. If you're looking to renovate your house, if you're looking to renovate your office, if you're looking to probably just change a few things around your office, then Stallion Construction Company will be able to support you on those services. And then we have Pathway Solution Services. Pathway Solution Services is a training firm. They have been offering our audience free trainings for the last, I think, the whole of season 3. They have offered individual trainings on their LMS. LMS is Learning Management System, where you learn self-paced. They also give you certificates for the lessons that you've taken. They also have been offering company trainings fully sponsored by Pathway Solutions. And tonight is not going to be different. We are going to still have offerings from Pathway Solutions, and we are going to let you know what's on offer this time round on your towards the end. So stay tuned if you're looking for training other than fully sponsored by Pathway Solution Services. And then we have the Institute of Pension Management. Institute of Pension Management, like the name spells it, it's a pension institute. If you're here, you're a pension manager, or you want to understand more how pensions work, or you want to become a pension trustee, you need to get in touch with the Institute of Pension Management. But better still, they actually have a school, a college. For those of you here who want to take on their CHRP courses, then Institute of Pension Management, we are able to do that for you. And then we have Fina Gardens. Fina Gardens Resort is a hotel located here in Naivasha. If you're here for the conference and you're wondering where to stay, we have been given good offers. Bed and breakfast is 4,000 shillings and bed only is 3,000 shillings. And just go and say you're from Atara Solutions and they'll be able to give you those offers. And then we have Essence Park. Essence Park is OSH, Occupation Health and Safety Company. They actually train, offer the mandatory trainings on OSH. For example, your OSH committee or other health and safety committee, the mandatory training, fire and safety, and also first aid. So Essence Park Limited, they have also launched a waste management program. So if you're looking for people who can support you in waste management in your companies, then Essence Park Limited do that for you. Then we have Panessa Training Institute. Panessa Training Institute is a carpentry school. If you're here and you wish to enhance your woodworking skills, or you're looking for carpenters to place in your workplaces, we have a pool of them and they can be able to come and do the work. Panessa, by the way, is one of the best furniture making companies in the East African region. Please Google them up and you know what I'm talking about. And then we have WeClean. WeClean have actually been nominated for an award this weekend. WeClean is a carpet cleaning company. If you have a carpet at home and you're wondering, what do I do with this carpet? It takes forever to take it to the cleaners, then WeClean, they actually have a machine that cleans your carpet within 6 minutes. I repeat, 6 minutes. So they pick up your carpet today, they'll be able to deliver it tomorrow. And they actually come and lift your furniture, remove the carpets for themselves. When they bring it back, they'll actually place the carpet back. Can you believe that? And they do that within 24 hours. So do not stay with a dirty carpet in your house, because WeClean are here to give you those solutions. And then we have Capula Mintito. Capula Mintito sell coastal snacks. If you're in Mombasa, for those of you who are attending LAC, make sure you get orders from Capula Mintito. They sell cashew nuts, they sell Simos gel, they also sell mabuyu. Their mabuyu is like no other. I have never tasted such fresh mabuyu in my entire life. Then we have Career Management Center and Ames College of Business. We have also partnered with Profiles International. Profile International is a company that offers Gino Certified Emotional Training Institute, but they are also the best in psychometric assessment. I repeat, psychometric assessment. So they have a training that is scheduled from 1st of November to the 17th. And this is IHRM certified with 6 CPD points. So if you're on this call, you're not able to attend the IHRM conference for your CPD points for the year, you have about 2 months, so you can do that by attending the psychometric training. This is being called Understanding Psychometric and Assessment Construction. This is for HR managers, HR directors, and HR professionals in general from 1st of November to 17th of November. And it's going to be on Zoom, and it's going to cost you only 48,500. I tell you, this is going to be worth it. I know Rose is on the call. Rose, you can put in the details on the chat so that people can get in touch with Profiles International. And then, of course, we have the LAC workshop, which is happening from tomorrow in Mombasa. They have a beautiful speakers. This is awesome. This is, if you're a leader and you need to attend a leadership training, it doesn't matter whether you are an HR or not. So long as you're a leader or you have aspiring to become a good leader, then the LAC workshop is something you cannot afford to miss. It's happening in Mombasa right now from tomorrow to Friday. And then, of course, the event of the year. This is our meet and greet. It's happening on the 18th of November at the Weston Hotel from 5:30 p.m. This is going, by the way, the offer ends this on 27th. When is 27th? On Thursday. We have an early bird offer that expires on Thursday. If you pay on early bird, you're paying 3,400. I know Kevin and Jacinta will be sharing the link on the chat right now. Please take advantage of this. Kevin and Jacinta, when you share the link, make sure you put the till number so that people can book today. Take advantage of the early bird offer. This is happening on the 18th of November, 2022 at the Weston Hotel. We are going to network, we are going to learn, we are going to bring serious speakers. You guys know us. You know, we don't joke around with learning. So this is going to be the event of the year. It's going to happen on the 18th. And then after the 18th, we'll have one more session on 22nd of November. And we are done with the year of Get It Right with Atara Solutions Season 3. And we shall meet again in 2023. So I know you're here because you want to learn a lot more about termination under medical grounds. And I know this is a very touchy subject. And I know today we are going to learn a lot. I know our speaker is quite good at this, but we just ought to think about the balance between the legal and the human. And I know that is what we need to clarify here today. And I know our speaker, if you're here from East Africa, he's got you. Don't worry. Don't think this is Kenyanized only. We got you covered, both from Kenya. Of course, the majority on the call I know are Kenyans, but even our friends from Kampala and Tanzania, don't worry, he's got you covered. What else have I forgotten to say? Oh yeah, so yes, Catherine Sidandi is our sign language interpreter. Our sign language interpreter has been fully sponsored by Frank of Frank of Pathway Solutions. He is paying for her full accommodation and transport and everything to attend the meet and greet. So Catherine Sidandi, I am hoping to see you tomorrow. I know we didn't see each other today, but we shall see you tomorrow because you help us be inclusive. So thank you so much for your kindness. All right, our speaker of the day is none other than Peter Kinyanjui. Peter Kinyanjui is a legal practitioner and also an HR practitioner. And he's been doing this for over 15 years now. And he has a wealth of knowledge. He is the legal manager at Agricultural Employers Association of Kenya. And he has a wealth of knowledge. I know, Peter, thank you for agreeing to do this on such short notice, but my friend actually is going through something like this. And I thought, you know what, let's just clarify to the HR professionals, to anyone who has gone through this, to anyone on the call who actually wants to understand the legal and the human side of things. So Peter Kinyanjui, please take it away.
Thank you, Grace, and good evening, alongside all the attendees for today's forum. Yeah, as you've introduced, my name is Peter Kinyanjui, and I'm glad to be taking you through this. Not so very, from the introduction, it is taken in different perspective, depending on where you are, whether you're on the side of capital or the side of labor. But ideally, through the few slides that I'll be sharing, and in the next couple of minutes, I will just be trying to ventilate on how we can do this in the most fair manner to our employees while not exposing capital. As introduced, I am a legal practitioner working with currently with the Agricultural Employers Association. Also a HR practitioner, a member of the Institute of Human Resources, and a certified data protection officer. For this purpose, I am called in to give a general legal framework that touches on how to separate on medical grounds in the most fair and legal manner, both in the interest of the employee and the interest of capital. So if you allow, I will share my screen and then we can proceed. I hope I'm clear from your end and you could guide me about how many minutes I have.
Yes, Kinyanjui, you have about 30 minutes and then we will do Q&A. I can see questions are already coming.
Very well. So I stand guided. I will go through these slides. Allow me a moment as I do the share. If you can confirm that you can see my screen.
Yes, we can.
Yes, we can.
Great. We request to switch off the video and then take us through these. Good. As I was prepared based on the audience, I would be trying to look at these in a broader perspective, because as we are all aware now, we are quite integrated in terms of the East African community, and more to speak, actually across the globe, being covered by the ILO convention. But as it is, I will be guided mostly by the laws of Kenya, but give comparatives of other jurisdictions, being maybe our sister countries, Kenya and Uganda, just to understand. So before we go to the actual part of termination, I would want us to look at the aspect of health in terms of employment. And as you know, Constitution of Kenya is the premium law of the land. So we need to start from what it provides in terms of any aspect that may be construed to be discrimination. And if you look at Article 27, it is quite express that a state or any person, and this includes an employer, should not discriminate. What I have highlighted there is what could be construed to be medical cases, and this includes pregnancy. And I know you get a lot of questions because there is a lot that happens alongside the entitled maternity leave. We are looking at health status. We shall also be looking at the disability. These are referred to as protected statuses, under which by no means any person, and including an employer, should discriminate or make any negative decision on any person, including an employee. And from the onset, what needs to be clear is that if anyone is found culpable of having made an employment decision, including termination, based on any of these grounds that touches on a medical ground, then you will be looking at quite some serious penal consequences in terms of damages if you're taken to court. So we want that to be quite at the back of our mind, that to begin with, you are not allowed to discriminate. So when you're faced with a case of medical ground, first of all, remember that medical status is protected by the Constitution of Kenya. And again, we also know that termination or separations is an administrative process. And under Article 47, if you want to take an administrative process, then you have to make sure that it is expeditious, it is efficient, it is lawful, reasonable, and procedurally fair. Again, that is the Constitution, and these are rights that are borrowed from human rights provisions under the United Nations, so it cuts across. And equally, the right to a fair labor practice is equally enshrined in the Constitution. And therefore, whenever you are contemplating terminating on medical ground, you need to be very, very certain that whatever you're doing is based on or can qualify to be what is deemed to be fair labor practice. So on that basis, I can take this close home to the Employment Act 2007. And again, it echoes the provisions of the Constitution, which is non-discrimination. Again, on the same basis, a little bit expanded here under Section 5 of the Employment Act to include, again, HIV status, which is a medical condition, and of course, echoing disability, pregnancy. We also have mental status, which is also a health condition. And again, the Employment Act prohibits any employment decision being made in employment that may amount to discrimination based on those grounds that are protected by the law. And the same act proceeds under section 30 to provide for a provision which is annual in nature, where an employee is given entitlement referred to as sick leave to generality of it is the law recognizes that an employee can fall sick and therefore need to take a medical attention. And it provides an anchor in the Employment Act and the Kenyan context for 7 days. Of course, that is the minimum. We realize that in many CBA's environment and also other regulations, the same is enhanced. On average, we are talking of 30 days in full pay, 30 days in half pay. And we will also see in other jurisdictions it varies, but each of the spirit of the law is that it is normal for an employee to get unwell, and employment decisions should not be used to target that employee. And what I have highlighted there is that this is provided as an annual entitlement. It means that an employee can exhaust full pay during the year, and then again, they half pay during the year. And it means once the year has lapsed, again, after the anniversary, they will be entitled to the same again the next year, and the next year, and the next year. And when we get these consultations, we've always underscored that part to take caution that an employee who maybe is getting regularly unwell should not be profiled to be unproductive, because those two things are very different. If you look at, just to look at, under the ILO, this is International Labour Organization provisions of sick leave. Again, the duration given by most countries as signatories to this convention is between one month to a maximum of 2 years in sick leave, whether with half pay or full pay. It is varied based on different countries. If you look at our neighbors here, we are talking about 126 days, where we're talking about 63 full pay, 63 half pay, that is in Tanzania. Look at Uganda under section 55, it provides for 1 month full pay, but for this jurisdiction, it does not provide for automatic half pay unless it is expressly provided for in the contract of employment. And maybe for the attendees from Uganda, what we'll do is to distinguish a little bit, because the Uganda equivalent of the Employment Act is the only unique one that does not actually provide expressly for half pay. And therefore, it actually provides that the employer has the discretion to terminate an employee based on that particular ailment, and especially if it goes beyond 1 month. And also it is not expressly provided for, and any terms in the contract of employment, CBAs, policies, and so on and so forth. So as we proceed, we'll be looking at the universality of this and go to section 41, which we all are very familiar with, especially the HR practitioners, that provides for procedures that should be adopted whenever an employer is contemplating taking disciplinary action. The Act is very clear that before an employer takes disciplinary action, whether based on performance, misconduct, or physical incapacity, and I want to underscore physical incapacity because in this case, you're talking about ailments, be it normal illnesses or be it incapacitation from workplace injuries or even injuries outside the workplace. The section is very clear that before you terminate, the employee has a right to have the same explained to them. And this should be explained in a language that the employee understands. You must tell the employee the reasons for which you as an employee is contemplating terminating their contract of service. And the law is very clear that such employee will be entitled to representation by the shop floor representatives, that is if unionized, and or represented by an employee of their choice, if they are not unionized. I want to emphasize this because for most practitioners, they take it as automatic. We even have provisions anchored in the policy, which to the extent that if someone has exhausted their SICO provisions, they are due for retirement on medical ground. And that is wrong. There is also a misconceived perception that when a doctor has actually advised you that someone is not capable of discharging their duties due to medical condition, then the general feeling and the general practice is that we do not subject these employees to the hearing. And if you don't do that, you will be contravening Section 41 of the Employment Act. And you know, once you contravene, the same is deemed to be unfair, discriminative, and penal consequences will be swift to follow. Once again, on that section, just to underscore, even if you have a letter from a medical practitioner recommending retirement from on medical grounds, that employee has a right to be heard just like any other employee. And this denotes that they will need to be given that letter. Sometimes this letter would have been sought by the employer themselves. Sometimes it is the employee having a fail that they are unable to work that would have procured the letter. Either ways, you have that recommendation for retirement on medical grounds on your desk. Now, the next thing that should come to your mind is you have a reason. Remember, under the law for fair termination, you must have a reason and also the right procedure. So if indeed there is no contest about the recommendation to retire the employee on medical ground, then you go to the next phase, which is what procedure will you adopt? And this is what now we are extending to the normal cases of terminations where you have to give someone, you invite them to a hearing. And in this case, you're telling them, we have since received this advice from the medical practitioner that you're unable to continue discharging your duties due to your medical condition. And therefore, you are invited for that discussion. Remember, this should not be construed to be a punitive kind of an action, because it is out of no fault of the employee. And therefore, it has to be created in a very conducive environment for employees to be able to say whether they actually concur with the advice or they don't. It is not unusual for the employees to actually accuse the employer of having procured this kind of advice from their favored doctors or the company doctors. And this is in essence what is required to come out during that kind of a hearing. And if those sentiments are presented that an employee is actually disputing the recommendation that you may be having, then you should know they have a right to a second opinion through a medical practitioner of their choice. And if that is requested, then the hearing should be adjourned and they should be allowed to go and present the same. If they bring in medical advice that is not in consonance with what you had gotten earlier, then you realize this becomes now a professional decision that is out of your hands as a practitioner or as an employer. And this should now be referred to the medical board, which will be looking at both the medical advices and looking at including whether they want to carry out any further physical examination, should be able to advise the employer that indeed this employee cannot continue working without putting his or her condition at danger or those of others. it is then now that you can proceed to execute the decision, having followed the process to the letter. And again, if you look at the section 34, you will read the spirit, and the spirit is you as an employer should actually ensure you have got sufficient provisions of proper medicine. And in this case, if you are away from, if you don't have a medical facility within the vicinity of your employment, you should endeavor to have a clinic in-house if you employ more than 100 employees. This is under medical treatment rules. And the whole idea here is we shouldn't be quick to take action on an employee who is unwell. Section 34 equally emphasizes that you as an employer should take all reasonable steps to ensure that you are notified of the illness of the employee as soon as reasonably practical. Again, here, we are looking at a precaution. You do not want to have terminated or dismissed or even retired an employee on medical ground, yet you are not sure and you don't have proper documentations of the medical condition of the employee. And most importantly, where you have not allowed this person a chance or an opportunity to explain themselves in line with section 41. So if you look at this, the spirit of the law is that termination or separation should come as a last result. What should precede that is that you have taken reasonable measures to assist employees in terms of their medical condition. And this is why we have most companies will be having their own clinics, they have medical covers and all that. And this is a gesture of goodwill that to begin with, we have an interest. We know we are employing people, not machines. And therefore, they can get unwell. And if they do, then your first recourse should not be to institute separation procedures, but first of all, to reach out and see whether you can be able to help them get well and return back to work, as opposed to targeting them and terminating their contract based on their medical incapacity. And I want to contrast these with provisions of incapacitation out of work injuries or occupational diseases. The line that I want to distinguish here, which I've seen quite mixed up with quite a number of practitioners, is that, for instance, you're dealing with a case of an employee who has been incapacitated by a work accident, and therefore they are not able to come to work. And yes, for the first, depending on the provisions you have for the full pay and half pay, for that period, they are on full pay, they are getting their full salary, so no issues. But then I want to start from where now you go to half pay, because that is a clear distinction from an employee who is being treated for work injuries, as opposed to an employee suffering normal illnesses. For normal illnesses, we say there is a provision for full pay, then half pay, and then the law allows you to freeze their salaries until that time they are well, or until that time they are entitled to another cycle of their sick leave. But in this case, for our work, an employee incapacitated through a work injury or an occupational disease, the moment you get to half pay, Section 28 of the Work Injury Benefit Act provides that you should top the difference. In short, an employee incapacitated by injuries or occupational disease should never be on half pay. And even at that point where the law allows you to freeze once an employee has exhausted the half pay, then if it is a work injury or an occupational disease, it means you continue paying this employee what is referred under the Act as periodical payment that should be equivalent to their salaries. And this should be done for a period not exceeding 12 months. So once again, I want to underscore that because I know it is quite confusing on quite a number of us, and with reasons, with sound reasons, that the work injury or employees incapacitated through workplace injuries or occupational diseases should, in the least or to a maximum of 12 months, be on their full pay, irrespective of the sick off provisions of your company. And this should run up to a maximum of 12 months, provided that if an employee is on some pay, then whatever you top up should at all time ensure that they are not getting paid more than they would ordinarily have been paid per month. I want also to patch the provisions of the Persons with Disability Act, and this more comes with workplace injuries, where we have to balance that by the fact that someone has been incapacitated and even compensated through the Work Injury Benefit Act, it inevitably means that this person may have suffered some form of disability. Now, this calls in for another statute, being the Persons with Disability Act, that now kicks in to protect that disability status of that person. And Section 15 of the Persons with Disability Act is very clear that you shall not discriminate on when you're making any employment decision against a person living with disability. And as you can see, it is basically in every HR process, whether you are recruiting, whether you're promoting, whether you're training, whether it's about wages, whether it's about retrenchments, you are simply cautioned by the Act and an equivalent ILO convention for persons with a disability that your decision cannot be based on the disability status of an employee. I started by echoing the same, that disability is protected by the Constitution, Article 27, disability is protected by the Constitution, by Employment Act at Section 5, and now disability is protected by the Persons with Disability Act at Section 15. So again, all these are safeguards to protect persons who may be well today, but then unwell tomorrow, either through a normal illness or a workplace injury. Having said so, and again, I don't want to delve so much on the Persons with Disability Act because I'm very sure we will still be able to look at it. But you realize the Act even protects against early retirement of a person with disability. It is very explicit that for a person living with disability, they cannot be retired before they are 60 years. So this is notwithstanding that your policies or your CBA may actually be providing for 55 years or something. It is different for persons living with disability. Let me quickly look at now the procedure that is meant to be followed, which I know I have, but I just want to cap it by one or two court cases, just to be guided by the Employment and Labor Relations Court about what is expected of you as an employer to consider before you take disciplinary action on an employee. This is ELC, Employment and Labor Relations Court, Kericho, petition number 002 of 2020, which is a very recent case. And I know you will go and read, they are available. If you just go and log into Kenya Law Reports, you should be able to download the entire judgment, just if you type the petition number. In this case, the judge, there was no doubt that the employee was unwell. In fact, there was a document from a medical practitioner advising that the employee be retired on medical ground. But unfortunately, for this particular case, what the employer did not do was the first parameter is that you're supposed to provide the petitioner or your employee with reasonable accommodation with a view of enabling them to continue with their work. So key highlights here from the Employment and Labor Relations Court. Yes, you have advice from a medical practitioner. And I know sometimes it will be give them light duties. In some cases, like in this particular case, they are saying, provide them with a facility or an environment at work that accommodates their medical condition, which may mean change their job if possible, adjust their work environment, adjust their sitting facilities in terms of their desk and all that. If they are working upstairs, consider getting an office downstairs. That's what the parameters of the course are. That let's see, first of all, that the person you're not terminating on medical ground cannot be gainfully engaged for any job that exists in your company. And you know that is a tall order, but before you do that, then you not have followed the right procedure and you will clearly be condemned, as the company there was condemned and paid around for, I think, 3 million shillings. Once you Google, you get the figure. And lastly, also in another case, which is ELRC 2610 of 2016, what the judge sums up again is that after consideration of the claimant's letter, it is clear that the medical ground cited for the termination, again here, was valid and fair. The judge has no issue that the employee is incapacitated and unable to do the job. However, here the only issue was that the clause 8, or rather the provision of this the policies of this company, was that if you get this number of years, automatically you get discharged by virtue of medical ground. Once again, I know you have these provisions. The judge said, if that the existence of such provisions in your CBA, in your contract, in your HR manual, cannot be used to oust the mandatory and express statutory provision under Section 41. So ideally, irrespective of what an employee has signed in your HR manual, in their contract of employment, that may even be providing for automatic retirement on medical ground, the courts have been clear. Those clauses are null and void. An employee must be heard. They must be given a fair chance to express themselves, and where possible, they must be accommodated to ensure that they are able to continue gainfully working if they are still productive. Having said that, I want to believe we are well guided, and I will take your questions. Back to you, Grace.
Thank you very much, Peter. Thank you very much, Peter. Today, we apologize our Facebook followers. We are actually live on Facebook, but for some reason, people cannot find the video, including our team. So I really do not know. But being about 400 people on this call, we are still making impact. We apologize if any of your friends are stuck. Please ask them to join. But Peter, let me ask you, there's this situation where somebody was asked to be assigned light duties, right? And then the office they work at does not have, or rather, what the person does, she sits at the reception and does data and stuff like that. So when they talk about light duties, what exactly are we supposed to do?
Yeah, thank you for that. And I know it's quite situations and advices that you're having to deal with so many times, the light duty thing. Eh? And what we have always advised is the doctor's advice should not end at telling you to give light duties, because as a HR practitioner, you may not know what actually constitutes light duty in line with the medical condition of an employee. It is not an issue for us to define light duties as collecting piece of papers around the work environment and all that. But you realize if maybe the employee is suffering from a back injury or maybe leg injury, that cannot qualify to be light duty. So what we've always advised is always write back to the doctor, explaining the nature of the jobs that you have, and let them tell you. It is better for them to tell you, assign them duties that do not involve bending, that do not involve standing for long hours, that don't involve exposure maybe to dust or to any kind of environment at your workplace. And I've always advised that if you do not have a work environment that this employee can be able to work without exaggerating the medical condition, you should be able to do so to the doctor, and therefore the doctor should be able to advise or recommend that the employee should be retired on medical grounds.
So at what point does the medical board come on board, come in?
Let me give a typical example where, for instance, you get one advice from one doctor that the employee is not fit to work. But then the employee comes and challenges that, because like you said, they have a right to be heard. They come and challenges and tells you, I am still able to work. And they indeed goes to another doctor and they're told, you can work. This means in your office, you'll be having two conflicting medical reports and you are not a medic. This is where now you escalate that issue to the medical board, because you are telling them, look, we have got two medical experts here that have given me inconsistent advices. How we want you to assist us, because on one side, you do not want to deploy an employee to a job that exaggerates their medical condition. And on the other, you are also careful not to be seen to have dismissed someone who is otherwise able, or terminate someone who is otherwise able to continue working. That's where now the board comes, reviews both of these opinions from these two doctors, and gives its own decision, which now should be binding to you. If they say proceed and retire, you proceed and retire. If they say this person can still gainfully work, then the decision is final.
All right, all right. Allow me to just say this. For the people who are putting their email addresses on the chat, kindly note that we will share the recording and you can write the notes yourself from our YouTube channel. You can listen again and again and again. The recording will be uploaded on our YouTube channel, but we discourage sharing notes because we have been character developed by people taking people's notes and using them as direct. So we will share the recording. You can replay it and you can actually read through and get to understand the presentation better. So if you may, we encourage more questions so that we clarify things for you as at now that we are here. All right, and thank you very much, Madam Kresha. I see you. Thank you very much for joining us. And yes, Peter, back to the questions. There's a question by Jared, before we get to Jared. How should one handle an employee who falls sick within the first 2 months of service, since illness can happen at any time? I'm asking this because 3 people have asked, does this provision for sick of 30 days and 30 days actually apply for people on probation?
Yeah, if you read strictly the provision of section 30 provides if an employee has worked for 2 consecutive months. So ideally, if someone is on a short contract for a month or 2, strictly reading the Employment Act, they're not entitled to sick off. But then after that, then they are entitled to sick off from the 2nd month onwards. So if it is a probation for 3 months, then it means on the 3rd month they're entitled, and so on and so forth.
Okay, and then we have these cases, and especially cases of mental health, which are on the rise. And you find that, for example, a drug addict has to go for rehab not less than 60 days, or somebody who suffers bipolar probably is in and out of hospital for longer than the 30 days and 15 days. Is there a way out?
Again, I would still call it medical condition. And I think what I need to reemphasize, and what I've seen play out a lot in court, is that we need to let this advice to be coming from medical practitioners. Now, and you realize by dint of the Persons with Disability Act, mental condition, you see the way they define disability, it could be physical, it could be mental, and that's where all these issues now come in, it could be psychological. So the moment the doctor advises that this is now not an issue of refusal to work, is not a behavioral issue, is not a performance issue, but it is a health issue, then if you had started some disciplinary action or separation process, maybe for non-performance, or maybe even someone may have been rude in terms of how they responded to something. If the doctor says this can be attributed to a medical condition, then you need to switch gear and now follow what we have discussed through this presentation and be guided. At some point, the doctor should be able to tell you this person with this condition cannot be able to continue discharging their duties as a driver, as machine operators and all that. And now that brings in the process to discharge them. Thank you.
Okay. And I've seen a number of questions, people asking, what is a medical board and where is it?
The medical board we are referring to is a medical, I call medical practitioners, something like that. This is the professional body where all doctors ascribe and they are registered under. There's medical practitioners and dentist board. They are actually, from what I have, where we have interacted with them, they actually, if you go to most of the county hospitals, they will have, they have a rotating schedule, and therefore they can be able to tell you when they'll be sitting in a certain county, and therefore you can be able to write to them. But yes, it is a medical practitioner and dentist board, and you can even search them on their website and even write to them, and they should be able to guide you on their schedule, depending on your locality.
All right, and Jared is asking, how expeditious should an administrative action be? Is there a specific time limit? Can 1 or 3 or 6 months be considered expeditious enough?
Expeditious means without unnecessary delay. Actually, the decision should be swift. They say justice delayed is justice denied. So, and this will depend on the complexity of the case you're dealing with. For instance, if the show cause you have is for absenteeism, how long does an employee need to explain or to show cause about why they didn't come to work yesterday? You realize if you allow them 2-3 days to respond to that, then that would be deemed to be expeditious. But then in some cases, you'll be dealing with some fraud, and you have to do a lot of investigation, and you have to give an employee enough time also to respond to those complex allegations and the audit issues, which could go for months. So I would say what is expeditious depends on a case to case.
All right. And then there's somebody, maybe you can clarify this, because a lot of young HR professionals who are joining the practice currently keep asking, or they're confused between the 30-day sick off and the 7-day sick off. What does the law provide?
If you look at provisional section 30, it will be providing 7 days and 7 days. But you also realize that within the same act, it provides that the conditions provided under the Employment Act constitutes minimum conditions, and that where there is any other law that provides for better terms than those provided by the Employment Act, then those other terms apply. So in this case, we'll be looking at your regulation depending on your industry. What does the general wages order provide for? If it is 30-30, you cannot apply 7-7 because there is another law that provides for better terms. If you have a CBA that provides for 53 or 54 or 60, then that applies. You cannot use Employment Act. So that is what I have always, because I know it's not an issue for us to be confronted by our bosses asking us, show me, where does that come from? So it is very clear, Employment Act provides for minimum, where there is another law that provides for superior terms, then such laws apply and not the Employment Act.
So at this point, we are saying that we do 30 days in full pay and 30 days with half pay, technically.
Yes.
Okay. So I hope that's clear. Mombi Ngunjiri says, do you need to give notice to the staff when it's time to retire them on medical grounds? If yes, how long?
Again, you realize is the delicate balance between holding someone who is unwell and unable to work even a day longer, because that day longer could exaggerate their condition and actually expose the company to even bigger problems. So where you have got advice from a medical practitioner and they tell you this person cannot continue working or doing this kind of a job, you cannot deploy them any further to do that job. But the only period you need is time to give them a fair opportunity to be heard, a fair opportunity to, there are so many other things that you realize once you have to separate with an employee out of medical ground. You know, this becomes what we call, it's not their fault. And therefore they cannot be punished for becoming unwell. So this period is meant to make it easy for an employee, and therefore, like I'm saying, it should be as immediate as the doctor has advised. And in most cases, immediate is immediate. They cannot tell you that after 2 months, they will not be able to work. They tell you this person with their condition cannot continue doing their job and therefore retire them. So don't deploy them a minute after you've been advised not to, because it could expose the company to bigger issues.
Wow, wow. And before we continue, allow me to recognize the presence of my good friend, Herbert Zake from Kampala. Thank you very much, my good friend. You are a fantastic person. I appreciate you. Thank you for sharing our flyer with HRMAO and all the practitioners in Kampala and all over the world. We don't take it for granted. Asante sana. We appreciate you and we recognize you. And thank you for joining the call as well. And moving on, Peter, there's somebody who's saying, kindly clarify, and I wish you could keep your answer short because you don't have a lot of time left.
Sure.
Kindly clarify the retirement age of persons with disability not working in civil service.
Yeah, it is 60 years. That is under Persons with Disability Act, irrespective.
Okay, because nowadays they're extending, especially in public service, they're bringing IDs with changed dates.
Yeah, clearly that is an advantage conferred to them, and of course subject to abuse.
Okay, and somebody is asking, somebody is ill and their contract is expiring in 20 days, but they've been given light duties for 60 days. What to do?
Yeah, SICO provision is a benefit for employees who are under contract of employment. So they continue enjoying the full pay or half pay up to the point their contract ends. Okay.
There's somebody who's saying what to do with the person who is bipolar, that is mental illness, who has exhausted their sick off. What more to do? I think at this point, the conversation today is about the legal side, but I want to encourage you to bring in the H in HR, because some of these things, people are productive, yes, but some of the illnesses they suffer may actually hinder them from being 100% productive, especially when it comes to mental health. So I would urge you, if you have a mental health case, maybe you need to come up with policies that support them, because they need it. They actually need the job to stay sane. They need the job to not commit suicide. So I would encourage you to actually employ the H in HR. The human part of human resources is also quite important. So develop policies that also cover you up, over and above the legal provisions. Am I correct, Peter?
You are.
All right. And Linda says, how do you handle an employee who has exhausted sick leave and he's mentally, okay, we've answered that one. Let me see. What happens in a situation where an employee is not of stable mind and therefore cannot comprehend the contents of the hearing notification among other correspondence from HR, and you cannot hold a coherent conversation either?
Yeah, that's why under section 41, you're told they can be represented by a shop floor representative or an employee of their choice. This is to assist in situations where you may not be understanding each other either in language or maybe out of a situation caused by their mental condition. But there need to be evidence of that on the minutes to show that you indeed we're able to give them as fast as is practicable an opportunity to express their situation.
On
Well,
the
there's
same,
another.
if you allow, Grace, I've seen a question. Someone asked, how about when they can't even recognize the people around them? That is because of the mental issue.
Once again, if this is demonstrated by the medical practitioner in terms of the advice you have that this person cannot comprehend the process, maybe out of their mental illness. In some cases, they may even be violent. So if that can be demonstrated that it is impractical for you to comply with Section 41, which is hearing, then that will be taken into consideration. Remember, it's about you demonstrating that you had put in place the mechanism, but maybe it was not possible to have it happen due to the medical condition of your employee. So the same would suffice in court if the same comes up.
Hey, there's another question here. Okay, wait. And casual employees, what happens? What are they entitled to?
To the extent that a casual employee works a day at a time and their contracts end a day at a time, then it means they are not entitled because they have not served for 2 consecutive months.
Okay. Okay, this is a long story. So Faith says, I currently have a case of someone who was away on sick leave, in and out since January, has not been sharing the sick off sheets, only shared 2 weeks ago after the matter was highlighted by departmental head. He's not reachable on phone to discuss. How can one deal with this as it's also bordering on disciplinary issue?
Yeah, on these under Section 34, the employees of the Employment Act, the employer has a duty to make reasonable efforts to find out where the employee could be. And even in normal separation, in cases where someone has gone, like in absconding, and therefore you're not able to reach them, the law requires you to demonstrate reasonable efforts to trace them. If you have tried calling them, you've tried sending people to their address, you've done registered mails to their declared addresses, and there is no response, then even if you take disciplinary action and separate, then you will be deemed to be within your right. The challenge is when you wait for them to bring to you the documents, because then it means you are aware they are unwell. Once you have the documents that they have been incapacitated, now you should abort your disciplinary process.
Okay. Some of these stories are long. How do you handle a case where an employee cannot handle his current role due to serious illness and cannot fit into the office role either, managerial or other light duties, e.g. use of computers? Can we terminate on doctor's advice? Or if so, what is the procedure?
Yeah, again, like I said in a nutshell, it is allowed by Section 41 to terminate a contract of employment due to physical incapacity. So if indeed the doctor has told you that this person cannot continue working gainfully for the role they were employed to do, then that's a reason to separate. The next thing is now give them opportunity through the procedural requirement, and you can go on and terminate them on medical ground. And this is irrespective of whether their medical condition is physical, is mental, is psychological. Either way, it is ailment. And yeah, the law allows that you can discharge them on that basis, subject to you following the process.
Yeah. Yeah. Okay, so there's somebody saying on the issue of pregnancy, what happens if someone takes leave after maternity period but doesn't report back after the lapse of leave days and doesn't communicate?
Again, that's a right question, depends on where they didn't come back. If it is a medical condition, then we are within the context of the discussion. If it is out of this, then they're absent and they can still be taken through disciplinary process. So the key is it the medical condition related or attributable to maternity that made it impossible for them to come back to work? If indeed they cite medical condition, then you must exercise caution in line with our discussions today.
All right. And then there's somebody who's saying, what should one do when you have issued a notice of termination without conducting a hearing? The employee has been away on sick leave for over 2 years on full pay. All other procedures were followed apart from conducting the hearing. The notice was issued about 5 days ago.
Unfortunately, if they are not heard, that is unfair termination. And if there's something you can do to sanitize that, you should immediately do it.
Yeah. What about injuries out of work?
The employee is still sick. Actually, it doesn't matter where they procured the illness. The only difference is the period you keep them under full pay. Because for that, it's different. If it is a workplace injury, we have said they continue paying them for a max of 1 year. But if it is an injury procured outside, then the CCOP provisions apply. Full pay, half pay, then you freeze the salary, but don't terminate. Freezing is not terminating.
All right. And then we have this, Josh. What if you have an employee who is sick but has a case to answer on misappropriation of funds?
We separate the issue, provided you don't do a hearing on an employee who is unwell. That may just come in to complicate and delay, because you may be required to wait until they are fit enough to answer to the disciplinary case. And these, we've seen cases, the courts have said it is unfair when you serve notice to show cause on an employee who is admitted in a hospital. It kills the whole process based on what we say, the humanity aspect, and the question of what is the rush. So that's the only disparity there, the difference there.
Okay. There's Haron. Haron, we have answered this question, but you have posted it like 4 times. Let me just read it. How do you handle a case where an employee gets an accident out of work and the medical report recommends a bed rest of 3 months? How do you handle sick leave, full and half pay days to support the staff?
Once again, I've said, if the accident is procured out of workplace, then you use the CCOF provisions under Employment Act, your CBO, your policy. That is full pay, half pay, then you don't pay. If the accident is procured at workplace, then you note there is nothing like half pay. They will be on full pay for a maximum of 1 month, 1 year under the Work Injury Benefits Act. That's the only difference. But either way, these 2 people are unwell, and if you need to terminate them out of that condition, then you have to follow the procedures we have alluded to during today's discussion.
Okay, and then probably the second last of these questions, we won't exhaust all of them. How do you treat a case where an employee collapses and is rushed to hospital only to be told that she has depleted her outpatient and company pays cash of 18K? Would you recover the money from the employee?
Yeah, the Employment Act does not require you to take care of the entire cost of treatment of your employee. So that goes to your medical policy. But the Employment Act and the medical treatment rule provides of you taking reasonable cost of the treatment of your employee. So that really depends. For some cases, 18,000 is reasonable. For some, it is capped at 10. For some, there is actually no medical policy at all. You're told to refer to NHIF. So that depends on your medical policy. And in this case, I want to believe the collapsing at work is not work injury related, because if it is a work injury or occupational, then you bear the full medical cost of treatment of your employee.
And Hannah is saying, which insurance will pay for 12 months salary for work injuries? I think that is provided under WIBA. You need to really negotiate your WIBA. Yeah.
Yes, they do. Check. They actually reimburse. That money is reimbursable. What you pay for an employee who is incapacitated is reimbursable through your WIBA cover.
Yeah. There's a lot of questions on terminal illnesses, yeah?
Okay, there's one question here. How about when an employee is incapacitated, that is stroke, and they are, will that be treated as a PWD case?
Yeah, I would still say yes, if they are completely incapacitated, then they're actually disabled. And it depends whether their disability impedes on their ability to work. If indeed they cannot work gainfully, then they become an ideal candidate where they can be terminated on their medical ground. Remember, the law is also protecting capital. Where an employee completely cannot gainfully work, the law does not compel capital to continue paying for that. Yes.
Wow. Okay, as we come towards the end, Millicent Ojwang is asking, how about if an employee falls sick and the employer is yet to close down a project due to completion of work in which the employee is employed and no other assignment is available? How do you handle that?
Yeah, like you said, if there is no other assignment that is available, remember from the court cases that I've alluded to, it provides that you must demonstrate that you have tried all possible means to accommodate them. So if based on the ailment, there is no or incapacity, there is no other job they can gain free discharge, then that becomes a typical case for retirement on medical grounds.
Wow. We are having a lot of questions here. I don't know if Grace might have. Grace, you're
Kevin,
back?
I'm here. Yes, as you look for the offers by Pathway Solutions, there's this question from Lillian. An employee has been on sick off since 2018 to date. He is due for retirement on 31st mwezi wa 12. Is it proper to proceed and terminate the contract? He's currently assigned light duties.
I would advise you let them retire. From my presentation, it's quite risky if you mess up termination based on medical condition. It is best advice. If it is just a few months to retirement, you let them retire.
All right. Oh yeah, Tabitha is saying, please advise, are consultants required to be covered on the company medical cover?
Consultants are not employees, they are contractors. So employment
Lucy
does not apply to them.
Lucy, I've probably skipped because we answered. How do you handle an employee? I have asked your question, Lucy, unless you want to repost it again. Are there law states that employees are not allowed to use mobile phones during working hours, like packaging staff in production department?
Unless it is based on something like maybe biosafety, or there's a lot of reasons that you may not be allowed. So it must be justified, but there is no law that prohibits. Those are conditions to be set based on the work situations at work and through your code of conduct and your policies, which must be justifiable. You cannot have an umbrella condemnation.
Yeah. And what is Abdul Karim, that person is your employee. What if of a casual employee who has been constantly renewing his or her contracts for 3 months, one after the other, almost for more than over 10 years now? That is your employee. Ama nini, Peter?
Yeah, it's as simple. That's not a casual.
Yeah, that's an employee.
Yes.
Yeah, and then, oh my God, I think we have a lot of people taking advantage. Yeah, Peter highlighted the procedure to follow when you're terminating on medical grounds. I think you guys need to sit back and listen to this webinar. But before we ask 2 more questions, allow Kevin to tell us the offers we have from Pathways today.
All right, as always, we have very great offers from Pathway Solutions. And as again, always, I'll ask all of us to share their interest through grace@atarasolutions.co.ke and Frank at Pathway Solutions services.co.uk. We have offer here for individuals. 3 people are going to be offered 2 LMS training courses. That is, you can choose either from call center training, which is an LMS training, anger management, conduction performance review, and performance management Both the 4 trainings are under LMS. The 5th training, which is managing personal finance, is going to be conducted on Zoom. The other training is on companies. We have 10 companies. Each will be provided with 2 training courses, and that is employee dispute resolution through mediation, crisis management, millennial onboarding, delivering constructive feedback, employee onboarding, managing employee discipline and absence, conflict management, that is getting along in the workplace. For those companies or representative of companies who are within this webinar and feel like their companies need such trainings, please share your interest to Grace and Frank through their emails. Last but not least, we have any 2 trainings workshop via Zoom or Google Meetup. Again, for those interested, share your interest through Grace at atarasolution.co.ke and Frank at pathwaysolutionsservices.co.uk. Terms and condition applies. They definitely, for those of us who've been having these trainings or rather got the opportunity to have access to these trainings, please allow others who've not to get the same opportunity. Back to you, Grace.
Sorry. So thank you very much, Kevin. I want to put the email for Frank here because most people get it wrong. Please copy Frank's email so that you can copy him and also indicate why you think you deserve this fully sponsored training. There's a question. Grace, kindly check on my question on termination of, oh yes, Jared, I had seen that. Let me just look for that because that's a very good one. Now, Peter, Jared is saying, when taking a disciplinary or administrative in nature action on a female staff who happens to be pregnant and the allegations are grave enough to lead to summary dismissal, and ultimately it happens so, will that disciplinary action be termed discriminatory because of the pregnancy?
On the face of it, I would say no. If the reasons that that pegs the disciplinary action are valid within the law, but you should know that pregnancy is protected under the Constitution, Article 27. It is protected by Employment Act Section 5 and also Section 46 of the Employment Act, which says that if you take any disciplinary action based on maternity or any condition that could be attributed to maternity, what I'm saying, it is alive and a very red wire for you to touch. But if you're saying what they did has absolutely nothing to do with their maternity condition, then the law allows you to proceed.
Yes. Well, my question about consultants, we have staff who have renewed their contract for service for about 5 years. Should we treat them as our employees? Additionally, what's your take on having new entrants being covered on medical cover, though on probation? Some employers are reluctant.
I didn't get that clear. You saying are they contractors or employees?
Contract for service.
Because Employment Act, WIBA, only applies to contract. I mean, does not apply to contract for service, but applies to contracts of employment. And the basic, and I don't know whether you have time to do this, maybe you can have another at some point to decide to discuss the whole aspect of contracts of employment. For now, you'll find that if someone has been engaged to do piecework on a contract basis, then they are not covered under the provision of this act. This deals with employees only.
Yeah.
I know that's a subject that could take another session on its own.
I know.
On management of contracts of employees.
All right. There's an interesting question here. There's a scenario here. An employee who has been working from his home country is transferred to a different country. He immediately applies for annual leave, which he is granted. After the annual leave, the employee brings to the employer a sick-off approval from his doctor. He keeps on sending in sick-off approvals from his doctor for 3 months and counting. The HR manual in the said organization provides 3 months sick-off with full pay and 3 months sick off with half pay. Now the employee is on half pay after exhausting the 3 months with full pay. Well, what should the employer do after the sick off period is over?
Yeah, once you exhaust full pay and then you exhaust the half pay as per your policy, the employee is deemed to be, you don't pay them salaries, the basic salaries anymore, but they are still deemed to be your employees until that time they recover, or the doctor says they are not going to recover and recommend retirement. So it's full pay, half pay, then freeze the salary, but don't terminate. That should not be taken to be automatic termination.
Yes, I think it's good to clarify that, because I think what a lot of people are wondering is, now that you have exhausted pay, full pay, what do we do? You know, and sometimes I understand, because it's a catch-22, because you're wondering whether to recruit or not. Do you feel this position? Do you have people on acting capacity until such a time when they're back? You know, all these scenarios. I understand where most of the, because I can see most of the questions here are, because you shared the process. By the way, please come back to the recording, and Peter shared the process of termination explicitly. And if you have any other further questions, please make sure you get in touch with the Peter. Peter, you can put, I don't know that you want a phone number or email addresses.
Yeah, I can share that. It's actually part of the slides that I had shared, the last one.
No, just put it on the
chat.
chat.
For those who don't want to put it down, you could reach at my phone contact, which is 0722 and 289 051.
There is Peter's number. There's a, okay, who is this telling me to check the question? What was it about, Mommy? Let me see. Evelyn, what was the question on? About cancerous employee. Please repost. There are so many questions that have been coming on. We are not able to keep up. Kindly assist in the event an employee has a doctor's guide on work and living conditions at work, but does everything different from what they should at work. Example, doesn't take medication, goes to dusty areas where they shouldn't, eat every meal they shouldn't as provided by the organization, and in turn falls sick at work and is rushed to hospital. What happens upon recovery, as this is a habit?
I think this is what is envisaged under Section 34 of the Employment Act, because it alludes to, you only take care of the cost if, and I mean, unless the ailment is not self-inflicted. So I would see that as a typical case of a self-inflicted ailment where the employer should not suffer both in terms of treatment or even sick offs out of a self-inflicted ailment.
All right. I think it's safe to say it's 9:26. In all honesty, we cannot exhaust all these questions. Peter is a legal, he's an advocate of the High Commission, and he's also an HR practitioner. And he also, for purposes of clearing doubt, charges for his services. So in case you're looking for his services, you either become his friend like Grace, who is able to call in for a favor, or you pay for the services. So get in touch with Peter. He's going to help you. He's an experienced HR and legal practitioner. Employment and all these laws are his specialty. Please do not hesitate to contact him. If you have not answered your question, I don't know, Evelyn, I cannot find your question on the cancerous patient. I don't know which one it was. There are so many questions on this chat. I really cannot exhaust them. I have tried to scroll up, and probably the question was way uko juu. I'm wondering, I don't like normally leaving people's questions unanswered, but maybe Kevin can scroll up as we finish. Okay, yeah, here it is. One of my managers is diagnosed with cancer. She exhausted all her sick days, took all her pending leave days, but we applied the H in HR and gave her 2 months to attend the chemo, which was fully paid. What happens next? She really wants to come back to secure her job.
Again, what I would want to underscore is we need to depend on the medical advice. What is the doctor saying after that condition? Are they still able to work even if in a different environment? If that is the advice, then that's what you should take. Is the doctor telling you they cannot continue working out of their condition? Then if that's what the doctor is saying, that's what you should follow. Are they saying you need to give them some lighter kind of duties? If that's what they are saying, that is the spirit of the law. So I think the question here is, we should not belabor ourselves as HR practitioners to decide on what is a clearly medical condition. Let's be advised by the doctors. Yeah.
I agree with you. I think that
Grace,
is
if you allow.
awesome. Mm-hmm.
There's one question, having mentioned doctors, from Dr. Lewis, who is asking, can Peter kindly expound on the Aga Khan hospital case of the nurse who was removed from light duties and compelled to undergo a delicate spinal surgery and succumbed? It was in the social medias, and that is, it happened, the case happened at Aga Khan Kisumu.
Again, maybe that is a little bit wide, but I think I would want to explain it or just make a very basic comment on it. And ideally, this is what I was cautioning employment against, going against any kind of medical advice. Because you maybe your pressure is against paying this person for another 1 month or so, and therefore, that's why we are contravening what the doctor has advised, or even changing what the doctor has advised. But then an employee who very well know that they risk losing their job if they disobey employer's instruction may continue straining to do the job for the purpose of keeping their employment. Now, if that employee wants to succumb because the institution has defined some clear medical advice, then you can imagine you're looking at a bigger problem than paying them for a month or two as you wait for them to recover. So that's the balance we need to take seriously. And once again, in underscoring, agree to be guided by medical practitioners.
Excellent, excellent, Peter. I think it's safe to say that before Peter gives us his closing remarks, I see we have really pushed today's session. I mean, the legal matters we never get to finish, but because we are here, I know Peter has done us quite some justice, and I hope you guys have gotten value. For those of you who are asking the recording, yes, it will be uploaded on our YouTube channel. And if you registered for the webinar, we are going to send the recording to you, the link, so that, and we can also share Peter's email address. Peter, there's somebody on the chat who is asking for your email address. But before we get Peter's, you can type it out, your email on the chat. But as we wait for Peter to give us his final remarks, Kevin, you want to say thank you to our partners?
All right. Okay, just a minute. Allow us to say a big thank you to all our partners who have been enabling us to bring to you these sessions. That is Balcon Housing, Stallion Company, Pathway Solution Services, Institute of Pension Management, Fina Gardens, SN Park Limited, Panessa Training Institute, Wicklin, Kapula Mintito, the Career Management Center, and College of Business and Technology, AIMS. Grace?
Yes, you go to the next page, Kevin. You're the one sharing screen, yeah? Yeah. Yes, and would like to welcome you for the psychometric and assessment construction training happening from the 1st to 17th of November. I repeat, understanding psychometric and assessment construction. So many of us nowadays cannot be able to ascertain the kind of people we are bringing into the workplace, and psychometric is one of the tools that we can use to actually get to understand people better and how to interact with them. So please take advantage of this training that's being provided by Profiles International. And get in touch with me. Rose, if you're still on the call, please put the details on the chat. If you're in Mombasa, please attend the LAC workshop. It's happening from tomorrow with Damaris Ndungwa, who was one of our guests sometime this year. So please do not miss out on the LAC workshop. And of course, the event of the year is the Atara Solutions end of year meet and greet party. We are going to network, we are going to eat, we are going to meet each other. We are also going to learn. We have a wonderful lineup of speakers. We have excellent DJ. And guess what? The dress code is a touch of African. So start shopping. Take advantage of the early bird offer. It's going for 3,400 if you pay by 27th of October. And it is going to be it's going to be at a Western Hotel. And of course, we thank Pathway Solutions for making sure that our sign language interpreter is going to be in the house. He is fully sponsoring Catherine Sidandi to attend this. So we appreciate you, Frank, and thank you very much for this. Peter, one sentence as your closing remarks.
Yeah, as always, it has been an honor and a pleasure for me to interact with my colleagues in the profession. And I look forward to future engagement. I know the time was limited, but then again, I want to believe we have enough takeaways for today. Feel free to contact me as we keep sharing this knowledge. Thank you so much and have a good evening.
Thank you very much, Peter. We appreciate you. Thank you so much for coming. I mean, I really don't take this for granted. I really, really appreciate you. So thank you so much for agreeing to do this and for always guiding us in the most simplified of ways. So, and our audience, I'm sure, is happy. And thank you very much for your contribution to the profession. And thank you so much, our audience, for being here. Of course, our team at Atara Solutions, thank you so much. I personally appreciate you guys. You guys are an awesome team, Catherine Sidandi included. And please don't forget to join our WhatsApp group for more information on what's happening on Get It Right with Atara Solutions. Somebody is asking where will the meet and greet be? It's going to be at Western Hotel in Nairobi. Jacinta, I think you can put that. Somebody was asking about our YouTube channel. The link will be shared as well. You can follow. There's the registration link for the meet and greet. Is going to be on the 18th of November at Western Hotel in Nairobi. And then if you want to join our WhatsApp group, the link has also been shared. And to you guys, thank you so much. We appreciate you. We love you. As always, my name is Grace Nzula. I am the lead consultant and trainer at Atara Solutions. And with me is Kevin Adipo and Catherine Sidandi. We appreciate you and asanteni sana. See you next week, same time, same place, as we handle another totally different matter, but matters that affect employers and employees. And if you're in Naivasha, please say hello to me. I am here for the 26th annual HR conference at Sawela in Naivasha. So without further remarks, thank you so much and have yourselves a good night. Kevin, you have music. I mean, I'm out of bundles.